Hi, I'm Christian Walters. I'm an attorney with the law offices of Barry Miller here in Orlando, Florida. I also serve as treasurer of the Central Florida Gay and Lesbian Law Association and as a member of the Orange County Bar Association's Special Community Projects Committee. Please note this video is for informational purposes only and is no substitute for legal advice provided by licensed attorneys in the state of Florida. Again, this video is intended only to cover topics within the state of Florida. For those of you watching that live in foreign states, which is quite literally any other state, just know that the information contained in this video may vary quite widely from the rules of law applicable in your home state. This video covers very broad overarching concepts that can change based upon very minute details with respect to each factual scenario, so be sure to talk to an attorney. The topic of today's discussion is alternative title vesting. What we'll cover in this brief video is an overview of additional ways different than standard ownership to own property with the intention of avoiding probate. By way of introduction, probate is a legal action brought at death to determine who inherits from a particular person's estate. This can be testate succession, which is a probate of a specific term of a will, or intestate succession, which is where the court will look at the familial relationships between the deceased and his family to determine who will get what. Probate, first and foremost, is very expensive and should be avoided and can be avoided. And if you have the possibility to avoid it, you absolutely should. Save yourself some money, or rather your children some money. And also it avoids some infighting that might happen between your heirs, your children or your family, or whoever's named in your will as the case may be. As such, many people find it desirable to avoid probate whenever possible, as we've discussed. With respect to real property, real estate, probate can be easily avoided with proper estate planning. This video will discuss a few methods to avoid probate and the pros and cons of each method, so let's get into it. The first method we'll discuss is known as a life estate. A life estate is an interest in land created by a conveyance, such as a deed, but can also be created in other ways, such as a will. A life estate gives land to one person for the duration of that person's life. The person holding the property for life is referred to as a life tenant. The deed can also specify to whom the property goes in the event of the life tenant's death. That person is known as a remainderman. Take, for example, a deed which says as follows: I, Christian, hereby convey my beautiful South Orlando ranch to Kayla for life with a remainder to David. Kayla will hold the property for the duration of her life, and upon her death, that property will transfer automatically without the need for probate to David, thus avoiding probate of my estate or Kayla's estate in its entirety. Many people can also transfer property to themselves for life, retaining unto themselves a life estate, meaning that upon their death, the property would transfer by operation of law to their named remainderman. In our example, David or Kayla or whoever is mentioned as the remainderman in the deed. Life estates are not preferred, however. Regular life estates differ greatly from what's known as an enhanced life estate that we'll go into a little bit later. However, under a regular life estate, the life tenant has very, very little rights. The life tenant will find it extremely problematic and extremely difficult to try to sell their life estate while they currently hold it. They'll also find it nearly impossible to obtain a mortgage on their life estate interest because a lender will only have a mortgage upon the property for the duration of the life tenant's life. So what lender in their right mind would put a mortgage on a property that might disappear the second you die? Furthermore, a life tenant can also be liable to the remainderman in the event that their use of the property causes any depreciation or loss of value to the property itself. That's a concept known as waste. So a life tenant could potentially be sued by the remainderman for any decrease in the value. Accordingly, life estates are good and do tend to avoid probate, but don't fit within most people's estate plans. Life estates can also grant a person a life interest in the property for the duration of a third party's life. This is known as a life estate per otra v. Returning to our example, in this form, I convey my beautiful South Orlando ranch to Kayla for the duration of David's life, with a remainder to Barry. So Kayla will have the opportunity to own and hold and live in that property for so long as Dave remains alive. The second Dave dies, that property is taken by operation of law from Kayla, the life tenant, and given to Barry, the remainderman. Again, life estate per Ocher V is a life estate for the duration of a third party's life. Typically, this method is used only when the life tenant is holding the property for the duration of the life of somebody else who will live in the property. For example, someone who's incompetent or incapacitated, or a small child in some instances. However, that method, again, is not preferred. You probably won't see it often in common practice and is better left to other methods such as a trust. Instead, more and more people are turning to what we've referred to as the enhanced life estate. You've probably heard of this form of conveyance as a ladybird deed. Ladybird deed and life estate, for all intents and purposes, are the exact same thing. A ladybird deed is a deed in which one conveys property to a life tenant, with the remainder to a third party, just like a life estate. However, the only difference in an enhanced life estate, the life tenant retains all the powers of control that a normal owner of property would have. This means that a life tenant can mortgage, sell, convey, encumber, lien, do anything they want with the property, lease it, for the duration of their entire life. They are the sole person who is entitled to 100% of the proceeds from the sale, and they don't need the permission of a remainderman to sell that property like you would need in a regular life estate. This method allows the life tenant to maintain, as we said, complete control over the property while they're alive, unlike the burdensome restrictions we've seen in a regular life estate. Also, for those of you that have purchased property before, you know well and good that every time you sell property, you are subject to documentary stamp tax. The good thing about a ladybird deed, or enhanced life estate as it's also referred to, is that upon the conveyance of a life estate from me, for example, and I retain a life estate in myself with the remainder to a third party, only de minimis or minimal documentary stamp tax are due, typically about 70 cents. There are also some federal tax benefits to a ladybird deed as well, so be sure to discuss those benefits with your legal and tax counsel. Another benefit of both an enhanced life estate and a regular life estate is that the life tenant can maintain their homestead interest. Homestead interests in the state of Florida generally manifest in three ways. The first is a restriction on forced sale. This means that a creditor, someone whom you owe money to, cannot seize the property to pay any debt that you owe them, and they can't seize specifically the property that is your homestead. Another benefit is that homestead provides certain restrictions on conveyances without the joinder of spouse, meaning that a married couple selling homestead property would have to have both spouses' consent. And lastly, and most notably, tax exemptions. Homestead does provide specifically about three different tax benefits. The first, we're all very familiar with, is that your annual taxable assessed value on your property cannot increase from year to year by more than 3% or the consumer price index, whichever is lower. The second is that you are entitled to certain exemptions from your taxable assessed value, usually up to $50,000 depending upon the value of your property. And the third is that you have the ability to port your homestead. What this means is that when you've had a homestead for a particular time frame, you are then able to transfer some of those savings to a new homestead. So the good thing about life estates and enhanced life estates is that you are able to retain that homestead interest despite only being a life tenant. A remainderman cannot claim any sort of homestead interest. Okay. Another method frequently employed by owners of property to avoid probate is titling the property in joint ownership. Typically in Florida, when two or more people own property, they have three choices to choose from. The first is known as tenancy in common. When I say tenants, I'm not referring to the terms of some sort of a lease, as that term's usually used. When I refer to tenants in this context, I'm solely referring to a method by which two or more people own property. So tenants in common is a method that two or more people own property. It can be in respective different shares. For example, if Dave and I own property as tenants in common, I can own 60%, Dave can own 40%, or I can own 50% and Dave can own 50%. It's completely up to us. However, upon the death of one of the co-tenants in a tenancy in common, that interest transfers to their heirs. And what I mean when I say that is the person who died, their 60, 50, 40, 30, 20, whatever percent will have to be probated by a court. And in that instance, whatever their share is, their heirs at law will receive that share and become co-owners as tenants in common. For example, if I die, my kids would inherit my share and they would become joint owners of the property with Dave. Tenancy in common does not have any creditor protections like we'll see in some of these others. In a tenancy in common, all the tenants, myself and Dave in our example, are all entitled to the use and enjoyment of the property in its entirety, and also must share in the obligations, so taxes, insurance, so on and so forth. So with the understanding that joint tenancy is not very effective when the goal is to avoid probate, most people turn to a joint tenancy with the right of survivorship. A joint tenancy with right of survivorship is another method of co-ownership between multiple people. The only difference is between a joint tenants with right of survivorship situation and tenants in common is that upon the death of one of the co-tenants, that co-tenant's share in the property automatically goes in equal share to the remaining joint tenants with rights to survivorship. So, by my example, Dave and I own 50% of my beautiful South Orlando ranch. Upon my death, the property will automatically transfer by operation of law to Dave, and vice versa. If Dave were to die, I would inherit his share of the property in its entirety. So, in both joint tenants with rights to survivorship and tenants in common, any co-owner can sell their property without the permission of any other joint owner. In tenants in common, I can sell my 50, 20, whatever percent interest to anybody I want. They'll become the co-owner with Dave. In joint tenants, I can sell my 50, 40, whatever percentage to Kayla. And then Kayla can step into my shoes as the new owner with Dave of whatever percentage I've sold her. In the event we have a joint tenants with rights to survivorship situation, the joint tenancy is terminated if I sell the property to Kayla. In that event, Kayla and Dave will become tenants in common with each other. And you can probably see how that would tend to result in maybe some infighting when someone sells a property and then the remaining owners now have to deal with that. So lastly, the third method is reserved solely for married couples. It's known as a tenancy by the entirety. It shares the same survivorship that we see in a joint tenants with rights to survivorship, meaning upon the death of one spouse, the property transfers again by operation of law to the other spouse. However, the benefit that's afforded to married couples under this particular vesting method is creditor protection. Unlike joint tenants with rights to survivorship and tenants in common, tenancy by the entirety has great creditor protection. What that means is that in essence, let's say I'm married to Carl, and Carl has unfortunately lost his job and is unable to pay his credit card bill. Ordinarily, the credit card company would come after Carl for the amount of whatever he owes on his credit card statement. So the credit card company, let's assume, has obtained a final judgment. They've sued Carl, they've won, they've proven their case in court, and now they need to collect upon that judgment. They can go after any property that Carl owns individually, but real estate that's titled as tenancy by the entirety with me, his spouse, cannot be touched. The only instance in which property held as tenancy by the entirety can be seized, if you will, by a creditor is in the event both spouses owe the debt. If I would have signed off on that credit card agreement with Carl or had agreed to guarantee the debt in some way. That's the only instance. So the big takeaway in the benefit of tenancy by the entireties is that the debts of one spouse cannot be used to seize property owned by both spouses. An added layer of protection is that tenancy by the entirety cannot be sold and cannot be transferred unless both spouses agree. But you might ask, okay, well, if I need their permission to sell the property, what happens if we get divorced? In that instance, pretty simple. Divorce severs the tenancy by the entireties and renders the former spouses tenants in common, subject to all those rights and obligations we just discussed. As you can imagine, deeds do create interest that we've discussed today, and those deeds are extremely, extremely hyper-technical. The non-inclusion or the accidental inclusion, as the case may be, of a single word and a single word alone can change the entire effect of a deed. It can render it void, or in some instances could put really strange constraints upon deeds. In fact, as a real estate attorney here in Orlando, one of the biggest things that I do is correct deeds in which these errors have been made. And in fact, our firm probates quite a large amount of estates simply because the deeds that were done were improperly executed, improperly signed, contained improper language in them, resulting in the need to probate and thereby defeating the entire purpose of trying to avoid it. So the takeaway there, please make sure to use an attorney. Additionally, with respect to a lot of these conveyances, there are tax implications as well, so be sure to bring those up with either your tax counsel or your accountant, as the case may be. On behalf of the law offices of Barry Miller, the Central Florida Gay and Lesbian Law Association, and the Orange County Bar Association Special Project Committee, I do thank you guys for joining us today on this video. And if you need anything, please don't hesitate to reach out to the Orange County Bar. Thanks.